The letter arrived on a Tuesday. It was addressed to both of us, in a business envelope, from a firm called Whitmore and Associates that I had never heard of. I opened it at the kitchen table while Liam was making coffee, and I read the first paragraph and I put it down on the table and I said, "Your mother is suing us." He turned around. He said, "What?" I said, "She is suing us for defamation and invasion of privacy." He said, "Over Zoe's film." I said, "Over Zoe's film." He put down the coffee. He sat at the table. He picked up the letter. He read it. He put it back on the table. The letter stated that our daughter's documentary project, which had been screened at an end-of-term school showcase and submitted to a regional student film competition, constituted a public disclosure of private facts that had caused Patricia Sheridan material reputational harm. The letter stated that the footage had been recorded without her knowledge or consent in what she had a reasonable expectation to be a private setting. The letter stated that the dissemination of the footage to the school community and subsequently to the regional competition panel had exposed her to public ridicule, damaged her standing in her community, and caused her ongoing emotional distress. The letter requested that we immediately withdraw Zoe's film from the regional competition, issue a written apology to Patricia on behalf of the family, and attend a mediation session with the goal of reaching a financial settlement for reputational damages. In the alternative, it said, Patricia Sheridan would proceed with formal proceedings. I sat at the kitchen table. I was very calm. I had the specific calmness of a person who has been carrying something for a long time, and who has just been given, by a development that is outrageous on its face, a complete clarity about what was always true, and what was always going to need to be addressed. I said, "She is suing our daughter." Liam said, "She is suing us over a film our daughter made about her life that included 47 seconds in which my mother said things to a 10-year-old that she said under her own power with no coercion and no instruction." I said, "Yes." He said, "I am calling a lawyer today." I said, "I know." He said, "Emma." He said, "I told Zoe 3 times she was misunderstanding." He said, "I told you I didn't think my mother would say those things." He said, "And now my mother is filing legal proceedings over the documentation of what she said." I said, "Yes." He said, "I am not going to be wrong about this again." I said, "I know." He said, "Tell me what we need." I said, "The best family law attorney in this county." He said, "Yes." He stood up. He picked up the letter. He said, "I want you to know that this is the last time she does something in my name that I do not fully back." I said, "I know." He said, "From this point, everything we do, I am present for it completely." I said, "Good." He made the coffee. He called the lawyer from the kitchen table before we had finished the first cup. Let me tell you about the legal framework before I tell you what happened next. Because the framework is the part Patricia's lawyers had not fully worked through before sending the letter, and the framework is the reason the letter was, in the assessment of our attorney, a significant strategic mistake. Our attorney's name was Carolyn. She had been practicing family and civil law for 22 years, and she had the particular manner of someone who has seen enough at very little, surprises her, and who reserves the specific quality of focused attention for the cases where it is warranted. She had reviewed the letter and the footage by the end of that first week. She called us into her office on a Thursday afternoon, and she laid out the framework. She said, "I want to address each element of the claim before I tell you my assessment." She said, "The claim of public disclosure of private facts requires that the disclosed information was genuinely private, that the disclosure was made publicly, and that the disclosure would be objectionable to a reasonable person." She said, "Let me take these in order." She said, "Was the information private?" Patricia's argument is that the kitchen conversation was private because it occurred in a domestic setting. She said, However, Zoe was present. Zoe is one of the parties to the conversation. In our jurisdiction, the recording of a conversation by a participant in that conversation does not require the consent of the other parties. She said, "This is one-party consent law." Zoe was present. Zoe made the recording as a participant. The recording is legally obtained. She said, "Was the disclosure public?" Patricia's argument is that the school showcase constituted a public screening. She said, "The showcase was a closed school event. The audience was the school community. It was not broadcast, not posted on public platforms, not commercially distributed. The regional competition screening, similarly, is a closed jury review." She said, "The legal definition of public disclosure requires a broader dissemination than a school hall event or a closed competition panel." She said, "And here is the third element, and this is the one I want you to focus on." She said, "Would the disclosure be objectionable to a reasonable person?" She said, "The disclosed information shows a grandmother speaking to a 10-year-old child. The grandmother tells the child that her dress does not fit properly around the middle. She tells the child that her cousins do not eat the way she eats. She tells the child that her mother is not raising her with kindness." She said, "The question the court will be asked is whether a reasonable person would find the disclosure of that specific content objectionable." She said, "The answer the court will give is, not when the content is a factual record of what was said by the defendant to a child." She said, "The defamation claim is even weaker. Defamation requires a false statement of fact." She said, "Patricia's claim is essentially that the footage shows her saying something she said. That is not false. It is accurate. She cannot sue for defamation on the basis that an accurate recording of her own words was made available to be seen." She said, "The invasion of privacy claim has slightly more surface texture, but it still fails on the one-party consent point and on the public disclosure definition." She said, "My overall assessment is that this claim, if they proceed, will be dismissed." She said, "And I want to tell you something else." She said, "If they proceed, we will request discovery." She said, "In discovery, we will depose Patricia Sheridan." She said, "In the deposition, I will ask her whether she said each of the things that are in the 47 seconds under oath." She said, "She will either confirm what the footage shows, which establishes the record permanently, or she will deny what the footage shows, at which point the footage will be played in the deposition with a court reporter present, and she will need to explain the discrepancy." She said, "Either outcome benefits our position significantly." She leaned back. She said, "I would recommend we send a response letter declining mediation and withdrawal, advising them that we consider the claim without merit, and noting that if they proceed, we will request full discovery." She said, "I will be surprised if they continue after receiving that letter." Liam said, "Send it." She said, "Yes. I want to tell you about the cease and desist. Because the response letter was sent, and Whitmore and Associates did not withdraw, they filed formally. And 1 week after the formal filing, a second letter arrived, from the same firm, addressed to the regional documentary competition, with a copy to us. It requested that Zoe's film be withdrawn from the competition on the grounds that it was the subject of active litigation. I sat with that letter for a long time. Not because I was unsure about the legal position. Caroline had already told us the legal position was clear. I sat with it because I needed to decide what to tell Zoe. She was 10 years old. A lawsuit had been filed over her school project. Her grandmother had sent a letter to the competition that held her film. I was her mother. I was going to decide how to carry this in the room where she was. I told her on a Saturday morning. I sat at the kitchen table and I said, "Zoe, I need to tell you something that is happening, and I want to tell you clearly, because I think you deserve clarity." She said, "Okay." I said, "Grandma Patricia has asked a court to say that your film should not be shown. She said, "What do you mean?" I said, "She has filed a legal case. She says the 47 seconds were private and should not have been in the film." I said, "Our lawyer says the case is not likely to succeed." I said, "But in the meantime, her lawyers have written to the competition and asked for your film to be withdrawn." She looked at me. She was quiet for a moment. Then she said, "Can they make us withdraw it?" I said, "No." I said, "That is your decision. Withdrawing is your decision, and not withdrawing is your decision. No one else's." She thought for a moment. She said, "If I withdrew it, what would that say?" I said, "What do you think it would say?" She said, "It would say the film was wrong, that the 47 seconds shouldn't have been there." I said, "That is one interpretation." She said, "But the film wasn't wrong." I said, "No." She said, "I didn't make anything up." I said, "No." She said those things." I said, "Yes." She said, "So why would I say the film was wrong?" I said, "You wouldn't have to say anything. Withdrawing is just an action." She said, "Actions say things." She said it in the tone she uses when she has reached the end of an argument and does not need to continue it. She said, "I am not withdrawing it." I said, "Okay." She said, "Tell the competition it stays." I said, "I will." She went to get a glass of water. She stood at the counter and said, "Is she going to keep going with the court thing?" I said, "I don't know." She said, "What happens if she does?" I said, "We go to court, and we show the judge the 47 seconds, and the judge decides." She said, "And then he'll see what she said?" "Yes." She said, "That's the same as showing it in the hall." I said, "It is, yes." She said, "Okay." She drank her water. She went to her room. I sat at the table. I was thinking about a 10-year-old who had understood with complete clarity that the 47 seconds were the record, and that withdrawing the film would be accepting that the record should not exist. She had understood it in the same moment she had refused to edit the clip out for the teacher. She understood it now when a lawyer's letter said it should be gone. The record should exist. It should stay in the film. The film should stay in the competition. That was Zoe's position at 10 years old, and it has not changed. The deposition took place 6 weeks after the formal filing. Carolyn had requested it immediately, as she had said she would. Patricia attended with her lawyers. Liam and I were not in the room. Carolyn was. A court reporter was present. The deposition was conducted in Caroline's office. I want to tell you what was in the deposition because Carolyn walked us through it that afternoon, and the outline of it is the most clarifying document in this entire account. Carolyn asked, "Did you say to Zoe Sheridan, in the kitchen of your home on Christmas Day of last year, that her dress did not fit properly around the middle?" There was a pause. Patricia's lawyer said something. Patricia said, "I expressed concern about her eating habits." Carolyn said, "I will ask the question again. Did you say that the dress did not fit properly around the middle?" Patricia said, "Words to that effect." Carolyn said, "Thank you." She asked, "Did you say that Zoe's cousins did not eat the way Zoe ate?" Patricia said, "I was making an observation." Carolyn said, "Did you say those words, or words to that effect?" Patricia said, "Yes." Carolyn said, "Thank you." She asked, "Did you say that Zoe's mother was not raising her with kindness?" There was a longer pause. Patricia's lawyer spoke at length. Carolyn waited. Patricia said, "I said that her approach was not a kindness." Carolyn said, "Thank you." She put a document on the table. She said, "I am showing the deponent a transcript of the audio from the footage at issue." She said, "I would like you to confirm that the transcript accurately reflects what you said in the kitchen on Christmas Day." Patricia read the transcript. She said, "Yes." Carolyn said, "Thank you." She said, "I have no further questions at this time." The deposition was done in 38 minutes. Carolyn told us. She confirmed every word under oath. She said, "The record now exists in two forms. It exists as the footage, which is the original, and it exists as a sworn deposition in which the defendant confirmed the accuracy of the footage word for word." She said, "They have, in attempting to legally challenge the footage, produced a document that permanently establishes the truth of the footage in a legal record." She said, "I want to be clear about what that means. It means that regardless of what happens with this case going forward, Patricia Sheridan has now sworn under oath that she said to a 10-year-old child that the child's dress did not fit properly, that the child's cousins ate differently, and that the child's mother's approach to parenting was not a kindness." She said, "That is in the record. That is permanent." She said, "I would expect a withdrawal within 30 days. She was right about the 30 days. The letter from Whitmore and Associates arrived on a Wednesday. It stated that Patricia Sheridan was withdrawing all claims. No reason was given. The withdrawal was filed with the court. The case was closed. There was no financial settlement in either direction. There was no apology from either side. There was a permanent legal record of a deposition in which the defendant confirmed, under oath, the accuracy of 47 seconds of kitchen footage. That is the outcome. That is what the lawsuit produced." Liam read the withdrawal letter at the kitchen table. He said nothing for a moment. Then he said, "She confirmed every word under oath." I said, "Yes," he said, "in an attempt to prove it didn't happen." I said, "Yes," he said, "and now it is in the legal record forever." I said, "Yes." He said, "I should tell you something." He said, "I am going to carry the weight of the 3 years I told Zoe she was misunderstanding for the rest of my life." He said, "Not in a way that breaks anything, in a way that keeps me honest." I said, "I know." He said, "I will not be wrong about her again." I said, "I know that too. Let me tell you about Liam during the lawsuit, because the lawsuit was 2 months of his life, and I want to give you an accurate account of who he was during it, not just the broad strokes. He had told me on the Tuesday the letter arrived that he was done being wrong about his mother. I want to tell you what that looked like in practice over 64 days. He called Carolyn every time there was a development before I did. He read the legal framework documents she sent, and underlined them and asked questions by email the next morning. He prepared a detailed timeline of every occasion over 3 years that I had reported something Patricia had said to Zoe, with the dates I had told him and the responses he had given. He gave this timeline to Carolyn unsolicited. He said, "I want her to have the full record of my failures of attention in case it matters." Carolyn said, "It may matter in discovery." It did not matter in the end, because the discovery did not proceed to full disclosure before the withdrawal. But the timeline exists. Liam made it. He spent 8 hours on a Saturday in February making a document that listed every time his daughter had told him something, and he had said she was probably misunderstanding. He handed it to a lawyer. He said, "This is the record of what I got wrong." He said it without self-pity. He said it in the specific tone of someone who has decided to be accountable in a way that is useful, rather than performative. I watched him do it. I sat at the same table where the letter had arrived, and I watched my husband make the most honest document I have ever seen a person make about themselves. He did not show Zoe the timeline. She did not need it. But it is in Caroline's file, and it is in our house, the original copy, in the folder that now holds the withdrawal letter, and the competition result, and the deposition transcript. The folder is labeled, Zoe's film, Complete Record. Liam made the label. He chose the title, Complete Record. He used those words. I want you to understand why those 2 words matter in this particular household. In this particular story, after the year we have had, complete record. The same instinct that had produced fair record on a sticker on a replaced iPad. The same understanding that the record should be complete, and should exist, and should not be edited or withdrawn. Liam put those words on the folder. Zoe had put those words on the iPad. I did not say anything about the connection. I did not have to. He had arrived at it himself. He made the bread on Wednesday. He labeled the folder. He is not done carrying the weight of the 3 years. He will carry it honestly. That is the person he is. That is also the whole story, told completely. Let me also tell you about what Patricia's decision to file the lawsuit said to the people who knew about it. Helen, the woman from the book group who had spoken to me in the car park, called me when she heard. She said, "She filed a lawsuit over Zoe's film." I said yes. She said, "She is suing her 10-year-old granddaughter's family." I said, "Technically she is suing us rather than Zoe." She said, "Over Zoe's film?" I said yes. There was a silence. Helen said, "The book group has asked her to step back from participation for a period." I said, "I didn't ask for that." She said, "I know." She said, "We made the decision ourselves." She said, "We felt that pursuing legal action against a child's school project was an action that required a period of reflection before normal membership could continue." She said, "That is our choice and not yours, and I'm not telling you for any reason other than you should know." I said, "Thank you, Helen." She said, "How is Zoe?" I said, "She won the regional competition." She said, "Oh." She said, "Tell her well done from me." I said, "I will." She said, "The complete and unedited film?" I said, "Yes." She said, "Good." We hung up. The book group, the community that had seen the 47 seconds in their own homes before the hall. They had made their own assessment. They had made it without being asked. Zoe made a film about a day in her life, and the honest account of the day included the kitchen and the 47 seconds, and the 47 seconds had followed its echo through the book group, and the school community, and a deposition room, and a legal record, and a national documentary competition. All because a 10-year-old declined a request to edit her own life. That is the true chain of the events. Every link of it leads back to that refusal. I want to tell you about the competition, because the competition result arrived the same week as the withdrawal letter, and the proximity is not something I am going to pretend is not meaningful. I believe in the separation of coincidences and meaning, and I maintain that they are often present at the same time and the same place. On the Wednesday, the withdrawal letter arrived. I also received an email from the regional student documentary competition. The subject line was, "Result notification, Year 5 documentary category." Zoe's film had won the regional competition. I read the email twice. Then I went and found Zoe in her room. She was reading. I said, "I have something to tell you." She put the book down. I said, "Your film won the regional competition." She said, "Which category?" I said, "Year 5 documentary." She said, "What does that mean?" I said, "It means your film was selected as the best documentary film submitted by a Year 5 student in the region." She said, "In the region?" I said, "Yes." She said, "The whole region?" I said, "Yes." She thought about that. Then she said, "What did the judges say?" I said, "I have the notes." She read the notes. The judges had written, "A documentary of exceptional honesty and emotional accuracy. The filmmaker demonstrates an understanding of the function of documentary as a record of lived experience, rather than a performance of experience. Particular commendation for the filmmaker's commitment to the complete and unedited account." The phrase "complete and unedited account." She set the notes down. She said, "They saw the 47 seconds." I said, "Yes." She said, "And they said unedited?" "Yes." She said, So the thing I didn't take out is the reason it won? I said, I think so. I said, do you want to know something else? She said, yes. I said, the withdrawal letter from Grandma Patricia's lawyers also arrived today. She was quiet. She said, the same day. I said, yes. She looked at me. She said, the same day. I said, yes. She sat with that for a moment. Then she said, can we have the bread today? I said, what? She said, Dad's bread. The bread from Saturday mornings. Can we have that today? I said, it's Wednesday. She said, I know it's Wednesday. I said, I'll ask Dad. Liam made the bread. Wednesday afternoon, not Saturday. He made it because Zoe had won the regional competition. He made it because the withdrawal letter had arrived on the same day. He made it because the kitchen smelled like the right thing to do. We ate the bread at the kitchen table. The three of us. Zoe said, I want to enter the next level. I said, what next level? She said, the national competition. She said, the regional winner gets to submit to the national. I said, yes. She said, I want to submit. I said, the same film. She said, the original version. Liam said, yes. She said, good. She ate her bread. The kitchen smelled like the good part of staying in. That is the smell she put in the film. The cereal and the school bus and the bread and the library. And the 47 seconds that she declined to remove. All of it, the honest account. National competition, original version, the complete and unedited film. That is what Zoe is submitting. That is who she is. Let me tell you where things are with Patricia. We have not spoken to her since before the lawsuit was filed. There has been no contact initiated by her side. I do not know whether the withdrawal was a tactical decision, or a personal one, or both. I do not know whether she has sat with what the deposition says about her, the permanent record of her own sworn words. I know that Zoe has not asked about her. I know that Liam has not called her. I know that the door is closed and that neither of us has moved to open it, and that we are not in a hurry. The door will open in its time, or it will not open. Zoe will be who she is in either case. She is the child who refused the edit, who declined the withdrawal, who entered the national competition in the original version. She is 10 years old and she is already the person she is going to be. I have been watching her become it for 10 years, and it is the most significant thing I have ever been allowed to observe. That is the whole story. Every word of it true. Every word mine. Here is my question for you. If your mother-in-law filed a lawsuit over your child's school project, rather than addressing what the project revealed about her own behavior, what would be the first thing you would do? Tell me in the comments. I read every one. One more thing about the deposition. About what it produced. I want to be clear about something I think people misunderstand about what happened. The lawsuit did not expose Patricia more than the 47 seconds had exposed her. The 47 seconds were already in the hall. The book group had already seen them. The community had already seen them. What the deposition produced was not a new exposure. It produced a new register. The 47 seconds existed in the register of a school project shown in a hall. After the deposition, they also existed in the register of a sworn legal statement. Patricia Sheridan confirmed under oath, in front of a court reporter, in a formal legal proceeding, that she had said to her granddaughter that the child's dress did not fit properly, that her cousins ate differently, and that her mother's approach was not a kindness. She confirmed it because she had to. Because she had filed a claim that required her to engage with the record. She had filed the claim to make the record go away. The record went into the deposition instead. I want you to understand what that means for the future. The 47 seconds can be dismissed as context-dependent footage that could be misinterpreted. The sworn deposition cannot. It is the record that she made of herself. It is hers. She made it in an attempt to erase what she had made before. She produced the most permanent version of the thing she was trying to erase. That is the full shape of the lawsuit and its outcome. The film is in the national competition. The deposition is in the record. The bread was Wednesday, not Saturday. The kitchen smelled right. That is the end.